Hello, this is Joe Gailey, and I want to invite you to another one of our educational webcasts on the subject, your business and your employees. What are your obligations? Today we're going to be talking about the difference between an employee and a subcontractor. And this is a very confusing area of the law, and it confuses many small businesses. One of the reasons it's confusing is because Congress, in their infinite wisdom, has never provided a definition of what is an employee. And as a result, they've left it to administrative agencies to provide definitions. And in my experience, the administrative agencies who are most active in this area is the Internal Revenue Service and the Department of Labor. And each of them has a little bit different definition. Under the Internal Revenue Service definition, they look at a 20-factor test, mostly to do with whether the employer can control the time and place of performing services. If you meet 10 or more of those factors, then you're an employee. If you meet less than 10, then you are a subcontractor. Now, there's also what's known as Section 530 of the Internal Revenue Code that many people rely upon. And what that says basically is this, that the IRS is precluded by law from reclassifying any subcontractor to an employee if, and only if, number one, the employer issued a 1099 for the services of that subcontractor, and two, use of subcontractors is predominant in that industry. Let's take some examples. In the real estate industry, almost without exception, real estate salespeople are treated as subcontractors, and it's predominant in that industry. So in that industry, it's easy to prove that it's done because you can get representatives of marketing companies and large firms to talk about it. And as long as you've issued the 1099, Section 530 should prohibit the IRS from trying to reclassify your employees. But let's say that you're a dental hygienist and your employer dentist is paying you as a subcontractor instead of an employee. Well, even if they issue you a 1099, issue the employee a 1099, then that's only half the test. The other half is proving that it's predominant in the industry. And I don't know how you can do that absent doing vast marketing tests among dental firms within the state of Georgia as to how they hire employees. And almost without exception, under those circumstances, those dental hygienists are actually employees, not subcontractors. Now, the Department of Labor also gets involved with interpreting this, and they also can misclassify or reclassify employees under the FLSA, because if in fact you're an employee and treated as a subcontractor, you may run afoul of either minimum wage or some of the other rules of the FLSA. Now, the Department of Labor also has a 20-factor test, but they also have something in their definition that requires that the services being issued or being performed are within the core of the business. Now, this makes a little bit of sense. Let's say that you're a manufacturing business, manufacturing bathroom cabinets, and you hire an accountant, an outside accountant, to come in and do accounting work for you. Well, even regardless of how much time they spend there, that's not a core function of building cabinets. So at least under the Department of Labor rules, they would not be an employee. However, this gets into another type of dispute. For instance, there's recently been a case, and I believe it's ongoing, the Department of Labor versus Uber. Now, everybody's familiar with Uber, the ride-sharing company. This was what happened. Uber initially, and probably still does, treats their employees as subcontractors, their drivers as subcontractors. The drivers supply their own car. Uber does have to approve that car. The drivers say when they're going to work, and Uber has to approve that. And Uber also has to do certain criminal background checks and traffic violation checks and things like that. The Department of Labor filed suit against Uber saying that these drivers were really employees. Uber defended and said, no, they're not. The Department of Labor said that driving transportation is your business, and these are the people providing transportation. That is a core function of your business. And Uber responded and defended by saying, no, we're not a transportation company. We are a matchmaking company. All we do is match the customer to the driver. And that's all we do, and that's all we get paid for. They lost in that case, but it's up on appeal, and to my knowledge, it hasn't been decided. So these questions can get very, very complicated when you get into whether somebody is an employee or is a subcontractor. The better rule is, for most businesses, is to avoid the issue, unless it's clearly defined that you can have subcontractors. For instance, the construction industry, the real estate industry, subcontractors are predominantly used. If you're not in those industries, you might want to stay away and treat people as employees. I appreciate your listening and tuning in to this webcast, and I want to invite you to join us for our next webcast in this series. And as always, these things are highly facts and circumstances based, so please don't use this presentation as your sole means of making a decision about your business. You should always consult with somebody knowledgeable on the subject. I appreciate it and have a great day.